we reverted back to the 1935 provision regarding the determination of probable cause. By the way, what do you mean by search warrant? Search warrant, this is in the nature of a criminal process akin to a writ of discovery. It is necessary because of public necessity, but however, it is not applicable in civil processes. This according to Jose Nolieto case. Jose Nolieto. Please also take note the requirement of probable cause under the 1987 Constitution that in issuance of a warrant, wherein only the judge shall determine probable cause, but it must particularly describe the place to be searched or person or thing to be seized. However, there are warrantless search lawful, which are lawful, enumerated by our law and our jurisprudence. But please take note that these exceptions or warrantless searches, there must still be probable cause before the conduct of a warrantless search. And in this probable cause, it shall be determined based on the facts and circumstances of the case. Okay? And therefore, if there's probable cause and there's no time to secure a warrant, the police officer may conduct a warrantless search. Otherwise, it would deprive the agents of their ability and faculty to act promptly, including the conduct of a warrantless search. That would sanction impotence or ineffectiveness in law enforcement to the detriment of the society. With respect to the exceptions of warrantless search, please take note that with respect to moving vehicle, according to Lohoing case, it is justified because it is not practicable to secure a warrant because a vehicle can move quickly out of the locality or jurisdiction in which the warrant must be sought. Please also take note that the vehicle's inherent mobility reduces the expectation of privacy. However, with respect to military and police checkpoints, it is not illegal per se, provided that the individual in such vehicles shall not be subject to body search and the inspection is limited only to visual inspection. Same also with stop and frisk principle. With respect to stop and frisk, there must be a genuine reason in the light of the police officer's experience. Please also take note that this is also justified for the interest of effective crime prevention and detection. And the reason or the rationale of the inadmissibility of evidence illegally seized is actually to conform and guarantee the constitutional right of privacy free from unreasonable state intrusion. To borrow the language of Judge Learned Hand, exclusionary rule is the only practical way of enforcing the constitutional privilege. Also, according to Justice Holmes and Justice Brandeis, in a government of laws, existence of the government will not be imperiled if it fails to observe the law scrupulously. If the government becomes a lawbreaker, it breeds contempt of law, it invites everyone to become a law in himself, it invites anarchy. Please also take note the rule in England. The courts are not concerned with how the evidence is obtained. The judges in England have the discretion to exclude evidence, although this discretion is infrequently invoked. So the principles in England, even if the evidence is illegally seized, it does not operate unfairly against the accused if it has some independent probative value. According to the Supreme Court in England, courts have repudiated the idea of using exclusion as a deterrent against illegal police activity. Like in Queen versus Sang, the Supreme Court said that it is not part of the judge to exercise discretionary power, over the prosecution as respect the way in which the evidence is used. If the evidence is obtained illegally, there is a remedy in civil law. However, if it is obtained legally but in breach of the rules of conduct of the police, it shall be subject to appropriate disciplinary authority. What the judge at the trial is concerned with is not how the evidence ought to be adduced by the prosecution has been obtained, but with how it is used by the prosecution at the trial. Same also with the rule in Canada before the 1982 adoption of its constitution. But after the adoption of its constitution, the Constitution of Canada grants the broadest possible discretion to trial judges, allowing an appropriate and just remedy for charter violation. Please also take note that in custodial investigation, remember that custodial investigation, it refers to questioning initiated by law enforcement after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Therefore, prior to any questioning, the person under custody must be warned of his Miranda right. But please also take note that Miranda right is not available under the 1935 Constitution. It is only available after the adoption of his Constitution of the 1973 Constitution. The purpose of this is to guarantee is to prevent involuntary and uninformed admission or confession that may obtain by law enforcer through the application of force, threat, or intimidation. But therefore, even if the Miranda warning is not introduced by the court, even if the Miranda warning was not informed by the person under custody, but he voluntarily or is continuously making admission or confession, then it is admissible in evidence. Please also take note that RA 1973-34 and reenactment is also part of custodial investigation. But police lineup is not part of custodial investigation. By the way, with respect to res inter alias acta rule, an extrajudicial confession is binding only upon the confessant, and it is not binding against admissible against the co-accused, because any confession made or implicating his co-accused is considered hearsay according to the principle of res inter alias acta rule. Because according to the rule, the right of the party cannot be prejudiced by an act, declaration, or omission of another. And also with respect to self-incrimination, this only refers to testimonial compulsion, and it covers only the production of, also to the reduction of papers and other chattels. Please also take note that the constitutional prohibition includes compelling a witness to submit a specimen of his writing, because the Supreme Court in that case said writing is something that more than action or moving the body or the hand or fingers. It is not purely a mechanical act. It includes the use of the intelligence and attention. Please also take note with respect to mechanical acts that is only determinable by simple observation, like requiring accused to submit the test to a struck virus, or compelling him to speculate morphine, or submitting for pregnancy test. Please also take note that with respect to self-incrimination, this is applicable not only in criminal cases but also to civil and administrative cases and such other proceedings. However, in case of custodial investigation or right against custodial investigation, this is only applicable in criminal cases. We have to distinguish between the two kinds of witness. First is the ordinary witness. He can only invoke right against self-incrimination from the moment when a question is sent to elicit an answer will incriminate him is propounded to him. However, with respect to accused, he can invoke right against self-incrimination from the moment he is called to testify to the witness stand by the prosecution. However, this is only applicable in criminal cases. In civil cases, it is authorized under Rule 132, Section 6. A party may call an adverse party as his witness. This is under the hostile witness rule. This also this take also note that the self-incrimination, it is based on the principle that a respect a government must accord to the dignity and integrity of the citizen. This is also based on the principle of public policy and humanity. Public policy because the accused is placed under the strongest temptation to commit perjury, and humanity because it would prevent extortion of confession by the rest. Please also take note the difference between the different exclusionary rule under the 1987 Constitution. In Section 2, it's about the unreasonable search and seizure. Section 3 is about privacy of communication and correspondence. In Section 12 is about the extrajudicial confessions or about the custodial investigation right. Section 17 is about the right against self-incrimination. Please also take note that in Section 2 and Section 3, in case of any violation, it shall be admissible in evidence for any purpose in any proceeding. However, in Section 12 and Section 17, it is admissible against him, meaning the confessor. However, in the case of People versus Sunga, in relation to People versus Johnson, in 2003, the Supreme Court says that it is not only admissible against the confessor, it is also admissible against his co-accused. any testimony he made implicating his co-accused is considered hearsay